Hi, everyone. This is Nita Raghawansi, president of MMF, and welcome. Thank you for tuning into yet another webinar. We're really excited about this one, as we have been about the others. But I just want to, while folks are trickling in here into the webinar, I'm just going to give you a little preface and a little update on MMF. MMF is a 27-year-old trade association for music managers and helps service the needs by providing resources, connection points, information, and advocacy efforts on behalf of managers and self-managed artists and the community that supports them. I hope you all are hanging in there with all this uncertainty. We've been hearing your questions and hopefully getting you some answers where we can. MMF is working in a coalition of other music industry organizations to ask Congress to for more support and for better support with fewer loopholes and issues specifically to our industry around the CARES Act and sort of the upcoming next version of the stimulus bill. As our industry is, sorry, did someone say something, Wesley?
Nope.
Okay, I just heard noises, sorry. As our industry is looking for assistance for those who have been financially hit, we are unique in certain respects. Although we're grateful for the assistance of Congress and of course that they have provided, the way that our creative industries work have been that we get paid through a combo typically for a lot of our self-employed workers, for a lot of our independent contractors, for a lot of our songwriting community, our sort of gig economy community, certainly our musician community. We are unique in that we get paid through a combination of the W-2 and the 1099 income, and often those haven't been necessarily handled well in the current PUA. For those who are not savvy to the acronym PUA, that's Pandemic Unemployment Assistance. So if you're not familiar with the Pandemic Unemployment Assistance, do take a look online and see if you or your artists qualify. It's definitely something important to be looking at, but it does provide for some assistance that we do hope that Congress can address around some of the challenges that our community are facing. And the challenges have mainly been around the application area. So I just want to let you know that there is a coalition in the music industry. MMF is part of that coalition, and we are trying to have Congress take a look and address those concerns. Let's see. And so going into, actually, while we're on the subject, if you don't know about it already, the coalition has also worked on a website, which is a really great resource. It's musiccovidrelief.com. We were part of a coalition of these organizations that had put up a website as a good resource to find various funding programs out there. It does talk about unemployment assistance. It talks about the SBA loans, and then it also has a great long list of all of the variety of funds that are out there: Music Cares, Sweet Relief, etc. So I've talked about this on other webinars, but I wanted to just point that out to you before we get started. So in general, the MMF is here to provide what we can during this time. We are an all-volunteer organization, and if anyone is interested in getting involved and helping out, please feel free to drop me an email. My email is Nita, N-E-E-T-A, @mmfus.com. And membership we are a membership organization. Membership is $75 a year. For those who are facing financial hardship, we are able to offer you deferred membership for 6 months. So if you do need that, please note that in our online application on our website, which is mmfus.com, and you can go mmfus.com/join to go to our membership page. And just know in general, you can always reach out and contact us. I gave you my email address, nita@mmf.com, or drop a line into info@mmf.us.com, and someone will address your email. Okay, so as a result of the pandemic, we have been curating this multi-week webinar series with the fabulous Wesley Ahara, our Vice President of Education and Membership. So thank you, Wesley. We've been trying to put on this webinar series to help our community understand their options on maximizing their income streams and securing funding and understanding all the pieces around that. And a crucial piece of that is to understand copyrights. Our copyrights help us to generate a big piece of those income streams. So there have been some legal developments in that area. And in general, it's always good to keep up with the Copyright Office. So we are thrilled to have our fabulous speakers here today, who are experts straight from the U.S. Copyright Office. We have Regan Smith, who is the General Counsel and Associate Register of Copyrights, and we have John Riley, Assistant General Counsel of the U.S. Copyright Office. So welcome to you both, and thank you so much for being here. And now, before we get started, Wesley, I wanted to introduce you again to Wesley Ahara. Wesley, do you have any special instructions for our webinar audience?
So generally, in case you haven't used GoToWebinar very much before, there are two main sessions where you as an attendee can interact with us. One is the chat section. So if you're having any problems with the webinar, open up the chat section and shoot the organizers a message, and it'll go to me, and I'll try to help you troubleshoot. And then if you have any questions throughout the webinar around the content, please submit them in the questions section, and we'll come through as the different areas of copyright are being addressed and try to make sure that everything gets answered. At the end, we'll have a dedicated Q&A time, and Nita and I will be hopping in across the rest of the conversation to make sure that some other talking points do get discussed as well.
Great. Thank you, Wesley. So without further ado, I'll let John and Regan, I'll let you guys take it from here, and I'll jump out of the magic squares.
All right. Well, all right, John, I guess here we go. We'll see how this works. So thank you, everyone. We are excited to be able to connect with you virtually. We wanted to give you an update of things that have happened over the last few months. And I think there's sort of a varied group of listeners, so we'll try to keep it accessible to everyone, but we wanted to run through some developments that have happened with what is happening at the Copyright Office with the Music Modernization Act, and some litigation and legislation developments. So to start with the Music Modernization Act, I think some of you may be, extreme experts in this, and some of you may not be as focused on what the new law has done. But in short, there was a switch in the law in the way licenses will work for the musical works on interactive streaming sites such as Spotify, Pandora, Apple Music, Amazon, Google, and so on. So for 110 years, the United States has had what is called a compulsory license for the reproduction and distribution of musical works. That is called a mechanical license. It's a different license and a different royalty stream. When Nita is talking about the importance of copyright for revenues, it's different than the performance licenses that are administered by PROs such as ASCAP and BMI. And it's also different from the licensing and royalties that you might receive on the sound recording side as a label or an artist, including those administered by Sound Exchange. But the mechanical license used for use of songs on these streaming sites, in particular, is the focus of the MMA, reforms it. It converts it to a blanket license for these digital services to cover their use as sort of like a one-stop shopping option, rather than going song by song, which was what was happening before. And of course, with all the millions of songs that may be on streaming platforms, I think this started to groan in the digital age. So this new blanket license will be administered by a new collective called the Mechanical Licensing Collective that was selected by the Copyright Office last summer, and it is controlled by publishers and songwriters with consultation from associations of publishers and songwriters, as well as a representative of digital services to help in operations. It's called the Mechanical Licensing Collective, and it has a few duties to process the streams that are made by digital music services, as well as royalty payments, and deliver the royalty payments to copyright owners. So this is it's a new attempt at a simplified graphic. So if you are one of the people very immersed in it, you can give us feedback on what it thinks. But we're trying to show just the flow of the duties that the MLC has. So if something is played on a digital music service, they will send a usage report to the MLC, as well as the royalties that will go with it. And the MLC will engage in what's called matching, making sure that the uses of the song side, the musical work, to a particular stream that was played gets identified and the proper owner gets paid. And they're going to do this in part by establishing a public database that anyone can check, including if you're a self-administered songwriter, but even if you're not, and you want to just like check and see that your Uber is there, but you might have a publisher or an administrator putting your works on. So this is the overall flow. The MLC has an updated website that they launched recently called the MLC.com that you may want to check out to get more information, including what I think they have a graphic of what types of information should self-administered songwriters start to begin to collect. So what does that have to do with the Copyright Office? Well, the Copyright Office is tasked for setting up, establishing regulations that govern this switch to the blanket license. We are the agency for copyright, so it has regulatory authority over many areas of copyright, including the old license. And we were asked to promulgate a number of certain rules governing this new collective that the United States is setting up. So I mentioned that the Copyright Office picked the MLC last summer. We then moved on into rulemakings, is the process for adopting a rule is called, by publishing a document in the fall, asking the public to talk about different areas. And then I guess it was last month, it was in April, we published notices of proposed rulemakings, proposing certain rules about the information that services may send into the MLC, the form of reporting that the MLC will send out to copyright owners, rules about the access to the public database, as well as confidentiality of the public database. And so we would like to hear from you if you have thoughts about what we've proposed as a rule or other thoughts about what we should be considering. There's due dates on this slide of May 22nd is the first due date for the reporting, and then the two notices that connect to information that can be shared, as well as information that needs to be protected, because as you can imagine, there may be a variety of business confidential information that's going to flow through this new unit with all of its duties that it has. So we would love to hear from you. You can go, I think John may be plugging how you can participate in this, but any type of comments, you don't need to be a lawyer, would be helpful.
Great. Really quickly, I was just wondering, as far as where feedback is typically coming from for you about this, what are kind of the main sources that you've been receiving for feedback of how to do these edits thus far?
Yeah, so since we're subject to something called the Administrative Procedures Act, it has to be somewhat formal when we set up a rule. So on copyright.gov, we have a link to where you can click and you can just type a comment, like a website comment, or some people, lawyers put together very, very formal comments, and anything is fine. We will consider it all. Our job is just to make sure that what we do as an agency is promulgate a reasonable rule. So this is why there's specific time periods. We want you, the people, the public, to see what information we're basing our decision making on. But it can come in any form. We're going to wait till the cutoff period to start looking at any of it. So I'm not quite sure what we've received yet, but we'll make this all public on our website too. And I think we've got some sites where John can sort of explain how you find things and how you figure out what's going on and like, how does this really mean for me? Because I think some of it does get a little complicated, but at the end of the day, it's going to affect where you get your money from and how you get money if you are a songwriter. So it's important, and we don't want it to be a mystery.
Were there any other questions on this section, or?
Do you want to start? Okay.
All right, so I will get to a little bit more of our web pages in a second, but one thing I did want to talk about is a duty that the Copyright Office has under the MMA, and that's to issue a report on best practices related to unclaimed royalties. So by July 2021, the Copyright Office is required to issue a report with the Comptroller General on the best practices to identify and locate musical work copyright owners with unclaimed accrued royalties, encourage claiming by those owners, and then ultimately reduce the instance of unclaimed royalties. Congress is very interested in making sure everyone who is due royalties gets them, and I think a lot of people are interested in the success of the MLC being able to do that. So this study is going to advise the MLC on some things that you think about when doing so. The study began on December 6th, 2019, when the Copyright Office had an all-day symposium looking at a number of different issues. We started off with an update from the MLC and DLC, and then talked about things like the past challenges of building a comprehensive music ownership database. Where did it fail? What other efforts, should we consider when we are standing up the MLC? How to match musical works to sound recordings. Long and short, services are very good at tracking the use of their sound recordings, but they don't necessarily match those to the musical works when they are inputting them into their systems. We also talked about how to best educate songwriters and publishers, where to reach them, what maybe different types of creators, the different circles that they run in, and how to get messages to them, whether it be online, through handouts, through in-person outreach, through their network. We also were very lucky to have some creators join us. I think you see some on the screen there, including Roseanne Cash. The report will be issued in July 2021, which, as time moves slower and slower, I'm not sure if that's rapidly approaching or far away. But right now, with all the regulations that Reagan had just mentioned, we're not quite asking for comments on the study right yet because we don't want to overwhelm all the different interests who are submitting comments to us. But generally, this symposium was important. It's to educate the public, so when we get those comments, everyone has an understanding of the greater issues that we're dealing with. And you can find the symposium and our policy study and our regulations all on our webpage. Right now, if you go to copyright.gov/music-modernization, you will find a lot of materials on our website related to the MMA. We centralize all of these here. It includes things like rulemakings, things like our paper handouts, our videos, circulars, legislative history, and some FAQs. The reason why we are building this website, not just because it's useful, but we have a duty under the MMA to engage in education and outreach, as do the MLC and DLC. We started our outreach the day the MMA was passed, with a speaking event on that day, as well as publishing this homepage. I think so far we've spoken at around 40 live events, including ones that Nita has been the moderator of, so we were very happy to have her there for those. We had more live events planned, including at South by Southwest and with AIMP. And we are changing these right now to online events, including a May 21st AIMP webinar. That's just the world we live in now, but we hope to be able to turn back into a lot more live events once it's safe to do so. For the meantime, our website has a lot of information if you have time, including, let's see here, several handouts that we've created, a 4-page in-depth handout on all the parts of the MMA, which includes the Classics Act and AMP Act, and not just the provisions that apply to mechanical licensing. We do have a dedicated 2-page overview of Title I, that section that does apply to the Section 115 mechanicals, called the Music Licensing Modernization Act. We've actually also translated that into Spanish and French, which hopefully will help some people. A pocket part for the lawyers of all the amendments to Title 17, as well as a couple of circulars that talk about Section 115, both in digital distribution and in non-DPD distributions. We actually just added another circular on the Classics Protection and Access Act, one on pre-72 sound recordings, and we'll have another one in progress up on our website. As a part of the symposium, we actually realized that a lot of people don't know a lot of these acronyms, some that I'm talking about right now, but others that are very much in the weeds. So there's an acronym glossary there if you'd like to take a look at that. And we're working on a lot more things, including some information on how to get paid. For those who prefer videos, we have a 2-minute introduction to the MMA we had a professional company create for us. We're very proud of that one. And also a 6-part tutorial on the MMA and different topics to discuss. So if you are finding yourself with some extra time and want to look, maybe you're a visual learner, you want to look at those videos, I think they'd be very helpful if you want to get a deeper understanding than maybe today and what we could give you on the MMA. If you're also interested in kind of the background about how the MMA came together, we have a web page about Congress and all of their different members of Congress discussing the need for the MMA and such. On our webpage, as Reagan mentioned, there is also on that MMA main page a link to all the regulations we're working on. And if you go through those different regulations and see ones that you would like to comment on, it's very easy to just click a button and follow the instructions to submit a comment. We also have a newsletter in case you want to join up and get information as we move forward over the next year or so on the MMA. So we are a source of all sorts of information. We hope you come join us in learning about that. We've been very busy with the MMA, but we have been busy on a lot of different fronts. I think, despite the world being a little bit slow right now, the Copyright Office is not. And I think I'm going to turn it over to Reagan to talk some about some litigation that is taking up our time too.
Thank you. I saw Anita pop up, but maybe not. Okay.
I did, but
all right.
I'll ask my questions at the end.
Great.
Okay. All right. So we wanted to cover 2 litigation developments in particular. There's been a lot of copyright litigation going on, so this isn't a whole deep dive, but on March 9th, the Ninth Circuit en banc court had an opinion in a case called Skidmore versus Led Zeppelin, and this is about the song Stairway to Heaven and whether or not it infringed the song Taurus, which was written by someone named Randy California by the group Spirit. We filed a friend of the court brief, an amicus brief in that case, because some of the issues that were raised rose to the point where the United States government felt we had what is called a significant government interest. And I wanted to sort of, there's been a lot going on, go through that opinion, because I think it sort of clarified, at least in the Ninth Circuit, what some of the standard is for infringement of copyright. There have been a lot of cases, I think, over the last couple of years. There was Blurred Lines, there was Katy Perry, some of those on the sound recording side, some of them are on the musical work side. But this one, Stairway to Heaven, when it came out, it went to what is called en banc, which means the full panel, as opposed to like all of the Ninth Circuit Court judges, as opposed to a 3-person judge, to sort of clarify their view of some of the issues in that litigation. And so there are 2 issues that the government was sort of watching for, and what we filed our brief in, and we were pretty happy with the outcome of the decision. So the first issue was, what are you even supposed to look at if you are in court for a copyright litigation? And the answer is you need to register. If it's a U.S. work, you need to register your copyright with a Copyright Office. And what you send into the Copyright Office is called the deposit copy. That is the scope of your copyright claim. And that has been the rule for a long time. And it seems to kind of make sense, but it raised an issue, I think, for works registered prior to 1976 if they were songs, because the Copyright Office was not allowed to accept a sound recording. And we know people create music not necessarily by writing something out. The Copyright Office was well aware of that at the time and had guidance saying, you know, if you're going to submit a lead sheet or something, make sure it has everything you want to be considered. But the office felt that its hands were sort of tied because the law at the time did not allow it to accept a sound recording as a copy of the musical composition. So this became an issue in the Led Zeppelin versus Torres case because it involved what the jury and the judge were supposed to consider. We all might listen to the MP3 of something, but what had been registered with the Copyright Office at the bottom right was the sheet music version. And so the court clarified that what was registered with the copyright is the scope of the copyright claim. That's, I think, the right answer, and it is helpful as the Copyright Office figures out how to register the copyright. You need to send us what you want copyrighted. I will say that going forward, as of 1976, the law changed, and we were able to accept recordings. So that's what mostly we get to register musical works. So I think were these different songs, that same issue wouldn't have come up so much. And if there's unpublished elements, they now became subject to copyright and could be registered with the recording version after 1976. So the next thing that is interesting about this case is they did, after they looked at the stripped versions, what are they supposed to compare to? The court opined that the instructions the district court gave to the jury were not erroneous. So judges, tell juries what to look at. And what was interesting was about the standard of what they could consider as copyrightable. So to have a copyright, there needs to be a modicum of creativity in the elements. And so copyright doesn't cover the basic building blocks of materials or expressions that are standard, stock, or commonplace. And the question was, how do you apply this to music? The jury instruction in this case that included a statement such as that, which Torres had challenged. And then the Ninth Circuit opinion said that's fine to give the jury that instruction. Copyright only protects the author's original expression, and it also said it does not protect ideas, themes, or common musical elements such as descending chromatic scales, arpeggios, or short sequences of 3 notes. And the opinion said, well, you know what, that's right. And they noted that the Copyright Office's compendium, which says something very similar, supported that position and said this is a musical building block that no one can ever know. You cannot have a monopoly over the note of a B flat or a descending scale. And it's kind of interesting. I went and looked back at it again, and they said, we definitely said 3 and 4 notes together. That's insufficient. We said 7 maybe. So in terms of what you need to do in California, somewhere within that line of a musical note. And they also said it was fine instruction to say, even looking at the package altogether, you need to, in this case, they didn't give an instruction to say you need to look at the list as a whole. And I think that was based on the limited amount. So that may give clarity to some of these cases going forward, but that was, I think, an interesting opinion in copyright law.
Hey, Reagan, I do want to come in here and ask a quick question. There's a ton of civil cases out there that, can come up in front of the Copyright Office. What are the elements, or what are some of the factors that you all look at in deciding to get involved in civil litigation? Could you comment on that?
That's a good question. Yeah. And sometimes people reach out to us because honestly, we're a pretty small staff. If there's something you think should be on our radar, I wouldn't necessarily assume that it is. We do need a little bit of a lag time because we go through the Department of Justice to go to court, and that goes through a whole process to ensure the United States position has been kind of everyone who needs to weigh in can weigh in. But we look at whether there's a significant government interest. And in this case, deciding what is in and out of the copyright is kind of a core duty of our registration program. And part of deciding whether or not to register a copyright involves determining whether or not the material is copyrightable. So I am one of the members of what's called the Copyright Office Review Board. And I know John has worked a lot with the review board, where we will look at whether something coming up for copyright, sort of like the end of the road and the agency's decision, is sufficiently creative. And in this case, since this opinion was engaging in a discussion whether it was appropriate to say that 3 musical notes is not copyrightable, for example, we thought that tied into our equities, and also just the posture of this case being potentially, you know, kind of the last word, because there's not very many en banc opinions on some of these issues, was a good use of government resources to file this brief. So if it's something that it's not unlikely to recur again, or it's sort of weird and factual, that we would be less likely to, but this case sort of seemed to be the right vehicle that we thought it was appropriate to weigh in.
Thank you. That was me. Okay, John, yeah, I guess you.
So the other case we were kind of asked to talk about is an update on what's going on with the litigation involving the rate setting for mechanical rates. Now, this is something that happened before the MMA and will be affected by the MMA in the next rate setting. But this is a little bit of an older Copyright Royalty Board decision that has, you know, been on appeal for a while, and it involves the mechanical license for, importantly, interactive streaming. So when you have on-demand streams, and it's for rates paid for musical works, not sound recordings. So it involves songwriters and publishers. The Copyright Royalty Board sets the rates and terms for the different statutory licenses, including this one. And when it did set the rates and terms for this decision, there was an appeal to federal court to see if they did it right. This, unfortunately, there's a lot of shorthanding I'm going to have to do because this is only a 1 hour long conversation. And I think the Section 115 part of the Copyright Act is now longer than the original Copyright Act. So it is very, very complicated. But the long and short of it is the Copyright Royalty Board in their Phonorecords 3 decision set what are called all-in rates, meaning that a rate that reflects the amount that would be appropriate price and the total cost of streaming a musical work. So it includes mechanical licenses and accounts for the performance license. And I need to give you a little bit of background about what the rate is to talk about the appeal. But when I do talk about the appeal, I'm just going to basically say what different parties are claiming, because it is live litigation and the Copyright Office is involved. It's not one of those cases where the Copyright Office was asked to participate. We also participate when the library or Copyright Royalty Board or ourselves get sued. So understanding that what the CRB did in this case is important. And the way that they structured the rates is interesting, being all-in rates with an alternative. It's going to be the higher of one of two calculations. One is called the total content cost, or TCC, and that's the amount paid by a service to a record company for the right to digitally perform a sound recording. So the calculation of the mechanicals will be a percentage of those royalties paid to the sound recording owners. The second part would be a percentage of the service's service revenue, which is, in short, what monies the services are making from doing their interactive streams. The reason that the CRB included a TCC component of the rates is it generally protects songwriters and publishers in cases where the service doesn't have a lot of revenue or is more likely deferring revenue. But the kind of biggest issue that the services were concerned with was that what would happen if the record labels wanted to, in the free market, increase their rates. The TCC prong does not have a cap to it. So the theory was that it would be difficult for the services if the record companies increase their rates, because that would also pull up the mechanical rates. At the same time, you know, there's a concern on the publisher side because, as I mentioned before, the rates are quote unquote all in, meaning you have to subtract the amount of performance royalties that the services are paying. And so if the PRO rates relatively went up, that means relatively the mechanical rates would go down. To solve that, even though there is no cap to the TCC, there is a floor for rates, so they don't go below a certain amount. And think about how the music world works. Songwriters get paid by PROs directly, but any mechanicals flow through the publishers. So publishers would be less able to recoup their money if there were less mechanicals available. That's kind of the background and context to this. In terms of the rates, what the CRB did was set, again, there are two different prongs. One, the percent of revenue. In 2018, it starts at 11.4%, and by 2022, it goes up to 15.1%. For the TCC prong, it starts at 22% and goes up to 2022 to 26.2%. And again, that's a little bit complicated because these rates are greater of, and there's also discounts for, performance rights. So it's not an easy way to describe how much or the rate would be going up. But in any case, Amazon, Google, Pandora, and Spotify appealed, as well as a songwriter and the publishers. The services claimed, and this is the standard for reviewing the CRB decisions, that the rates were arbitrary and capricious. They also complained that they didn't have enough opportunity to comment on the final rate structure. And they said that the rates were retroactive. The CRB gave its final decision. It had an initial decision much earlier, but a final decision published in the Federal Register in 2019, but the parties had proposed rates for 2018 to 2022. There's also an important issue about the definition of service revenue as it relates to bundles. The way that I think people had described this is you need to account for the value of a music in a bundle, and the example I think given in court was if you sold one ice cream for $1, you would never say that if you sold two ice creams for $1.06, that the second ice cream costs 6 cents. What the Copyright Royalty Board essentially did was create a rule that said use the standalone price of what the music would be valued as, or what the service rather is generating for revenue as a standalone. So that's what the services were claiming. The publishers had one issue that they filed after the services filed their appeal. That was based on how to count service revenue properly related to subscriber counts for student and family plans. For our purposes, the United States government, we have a fairly straightforward position. Basically, we are saying that the determination was not lacking in rationality. It was not arbitrary or capricious. The CRB had the powers and the evidence to do what they did in the ultimate determination. And without speaking about this case in particular, the DC Circuit gives a lot of deference to the CRB, and part of that is because the CRB is always in a tough spot. Rates and terms of opposing sides rarely approach each other. It's not like the parties are fighting over a single line where you can say, oh, I want 10 cents, oh, I want 8 cents, oh, it's 9 cents. It's far more complicated than that. I'm hoping, we might hear a decision this year. The oral argument was March 10th, but Phonorecords 4 starts in 2021, and we'll use that new willing buyer, willing seller standard that the MMA created, and that's kind of just the basic update on what's going on with the rates in the Phonorecord 3 proceedings. I will add that the Web 4 proceedings, which set rates for non-interactive streaming on the sound recording side, is going on now, but oral arguments in that case before the CRB were delayed until at least June due to the coronavirus. And Congress has been very busy with coronavirus-related issues, some involving the office, but Congress still has an eye on copyright issues. I'm going to hand it back to Reagan to start talking about some of those congressional initiatives.
Thank you. One thing, I guess, just to pick up on the Web 5 proceeding, I think the arguments right now are July 24th. And when you said that the issue of retroactivity being an issue for setting the Phonorecords decision, which is subject to litigation, as far as how the pandemic is going to affect that, it's definitely settled law that if everyone agreed, rates could be retroactive. So that may be something the copyright royalty judges will look at as they consider their timing. But I definitely don't want to speak for them. But the CARES Act contains a number of provisions, relief provisions, which Nita laid out in her introduction, which, I mean, that's probably of more immediate importance to many people. But there is also an update to the Copyright Act that we just wanted to flag and make you aware of some of the changes that have happened. John, I think you might be frozen, but if it might be my screen, but if it is yours, if you're able to, can you move to the next slide if we are, if it's not on my end? Okay, well, it's not, at any rate, I can just speak to it. There is an emergency relief authority given to the head of the Copyright Office to change some of the deadlines, either already in the rules that we've set up for sending something to the Copyright Office or in the law itself, even if it doesn't involve something that comes into the Copyright Office. And that it's not without precedent. There was another change made during World War II, and it was difficult for things to be exported or imported into the United States. But this authority is, I would say, fairly broad, and it does expire in December for that reason, presumably. But we took a look at all of the various deadlines because of this really unprecedented, effect of all of these shelter-in-place orders. And there's been 3 adjustments that the Copyright Office has made. So the first is to register a copyright. So registration has a time associated with it to register before infringement starts or within 90 days of publication or like your release in order to be available, have statutory damages and attorney fees available if you do need to go in for litigation. So we extended that deadline. If the pandemic is affecting your ability to send in a copy of your song or your recording, that is fine. You can just say that with a declaration once we're all out of this horrible situation and get sort of a grace period in this timing. The second change we made was one relating to the rights of termination. So if you are an artist, you have certain rights to terminate an agreement affecting your copyright that you may have entered into a number of years following later. So you could get out of an agreement with a record label or a publisher and get your copyright back or use that to renegotiate. So there's specific timelines in the statute, however, related to when you need to serve a notice upon the other party that you made the agreement with, and you also need to send a record of that to the Copyright Office. If your ability to do that is being affected by the pandemic, you also have a grace period. And then the third instance is I think a little more targeted, and it relates to payments in right now the kind of old universe that we are in for the mechanical license, the song by song license. If you are receiving notices because it's still song by song or royalty payments through a service that is being affected and unable to do this physically because of the shelter-in-place type orders or various shutdowns, they have a little bit of time where they can wait until a bit of a grace period, and then they need to true up and provide clear explanations of all that. Now that is only for the compulsory license, and I think the only entity I'm aware that this is affected are notices that are going through the Harry Fox agency, which is in New York City and had to shut down its New York City offices. And so then when that lifts, they will provide the detailed follow-up information and payment only if you were already receiving something in the mail as opposed to direct deposit or electronic. I know that's sort of a mouthful, but I also know it's very important that to the extent we can, I'll continue as normal, particularly when it involves royalty payments. We are. So you can opt into direct deposit if you had a voluntary agreement, if you're perhaps getting paid through a larger deal, whether it was on the performance side or is affecting different territories. This does not apply to you, like, don't worry. But that is sort of the adjustment to just approximate where we would all like to be that for this situation as much as possible. So if there's something else you think that is a problem related to the pandemic, you can reach out. We would like to know because we do have this new authority in the CARES Act. John, you said you were offline, I think. I'm gonna, like last call.
It does look like John is stuck offline.
Okay. Well, I will dive into the AMFM Act, and if he pops on, he can chime in. But the AMFM Act has been introduced in the fall, I believe, in the House and the Senate, and it provides for a terrestrial radio right for sound recordings, which right now doesn't exist. And there's been a few bills that have been introduced over the years attempting to sort of rectify this, because the United States is a little anomalous in not having this this sound recording right. That is not true on the digital side, because we have Sound Exchange and we have the 114 license that accompanies it. But this is a change that the office has long supported, and we'll see what happens to that. And then finally, the CASE Act. This is called the Copyright in Small Claims Act. And so this is a proposal to establish a tribunal within the Copyright Office of 3 administrative law judges, kind of similar to the Copyright Royalty Board, but instead of diving into very complex disputes, they would handle small copyright claims. Oh, hey, John, you're here.
Hello.
Hello, you're
Modern
back.
technology. So sorry.
Great. Well, I'm going to let you turn over. I covered AMFM Act, but if you want to talk about the CASE Act, I just hopefully gave the basics of there would be a tribunal to cover small claims in the Copyright Office for people who feel like they're shut out of federal court because the costs are too high.
Yeah.
Real quick, John, I just want to remind the audience, if you have questions, feel free. I do see folks typing them in. We will have a Q&A at the end, so just feel free to keep type your questions in there, and we'll get to it, hopefully. Thanks.
All right. So, can you, if Reagan, are you sharing your screen? Can you forward the slide?
No, I still see the same. I think you're frozen. Maybe just talk about the CASE Act and we can wrap up. But
Okay. Interesting. So as Reagan mentioned, the CASE Act is a potentially new tribunal to create the authority to make decisions on a voluntary basis of 3 officers in the Copyright Office. It would create these 3 new officers. 2 would have experience as a copyright infringement attorney or adjudicator. You have to represent both sides. And then 1 has to have experience in ADR. The proceedings would be conducted remotely, which hopefully would go a little bit better than my experience right now. But there would be limited discovery, a streamlined process. Generally, court is very expensive and time-consuming. It could take $350,000 to get a copyright case going through appeal, and can average over 2 years in some jurisdictions. So this would be a much quicker way to have parties kind of decide their different disputes. The types of claims that could be brought in a CASE Act tribunal would be infringement of Section 106 rights and all those defenses. A declaration of non-infringement. So if you had a dispute over whether something was fair use, for example, but you didn't need to decide how much money you would pay, you just didn't know if it was fair use, you could bring that before the CCB. TMCA claims for Section 512F misrepresentation, but not 1202 claims for removing copyright management information. You have limited counterclaims, but in general, these are all copyright and copyright related claims. We're not going to be taking trademark claims in front of the CASE Act tribunal, just copyright. You can have a lawyer if you'd like, but it's not necessary. We are hoping that different legal services groups will jump in and be able to help parties on both sides if they're interested in that. There will be some filing fees required, which we're hoping will deter some insincere claims. What do you do if you win? Well, if the person does not pay, then you would file with federal courts to enforce the judgment. But if you lose a case, there are limits on the review process. The CASE Act does not allow parties to just relitigate claims in federal court. And importantly, the decisions are non-precedential. So whatever decisions are made in the Case Act, we're not going to have courts rely on those for other decisions in different circuits. But they will happily be decided by 3 copyright experts, which is hopefully going to get to some very good decisions. And if parties want to refer to the decisions of the Case Act Tribunal, we will be posting them on their Case Act, the CCB website, and people can look and say, you know, this is very similar to the decision that was here. I think that we will know what will come of our dispute, and maybe parties could settle it on their own. This is a voluntary opt-out system. There will be several notices, a couple of notices sent to the respondents allowing them to opt out. The first notice by the claimant starts a 60-day clock to opt out, but that could be extended in the interest of justice. And then if that defendant never responds, then they have 30 days after a notice of default from the Copyright Claims Board, which is what we're calling this Case Act Tribunal. I think the question about, well, if this is a small claims court, what does that mean? The total damages cap for all claims is capped at $30,000. It can be actual or statutory damages, but that's much less than federal court. In fact, even though the cap total is $30,000, it's only $15,000 per work, or 10% of what a total maximum damage under statutory damages could be. If the work's registered after the infringement, you can still get, at least under the Case Act, $7,500 max per work. And part of the reason for that is because discovery is very involved and very expensive, and sometimes parties just want to get a resolution. But again, that is a cap, it's not a minimum. Parties can get decisions of much less than that. The CCB will not be issuing any injunctions or any impoundment, but the parties can agree to stop doing certain activities. That agreement can be included in any award. There's no general fee shifting provision unless there's bad faith conduct, but there is a cap to that. That's generally it with the Case Act. Congress is, I will say very briefly, interested in a number of other different issues, and I'll just touch on them very briefly before we turn to questions. Felony streaming, under current law, there's only felony for reproduction and distribution, not performance. This was back in the day when this law first came out. People said that this is the law that might jail Justin Bieber, but that is not the intent. There's also interest in Congress in kind of revisiting the DMCA in Section 512. They've noted that the DMCA is showing its age and have had hearings. And then finally, Congress is also interested in taking a look at state copyright infringement, and that was prompted by the Allen v. Cooper case. So that is kind of a quick overview of what Congress is looking at, and I guess if we have any questions, we have some time.
Great, well, thank you. I think Wesley might come on to go through some of the questions, but I just wanted to ask just a couple of things. If we could back up to the MMA for a moment and the MLC, and I'm so glad you guys have that education and outreach materials, and that's tremendous. And I was wondering, you know, I wasn't sure I saw in there, and you might have mentioned it, but I want to just double check. I know a lot of managers are asking, hey, you know, do I need to, like, while I'm sitting at home right now and the artists are off the road, should we work on our data and getting our data together? And if so, what is that? Are there going to be any sort of materials put out about what are the fields of data that, you know, I mean, of course, a lot of folks already work with their their digital distributors to sort of put that together, and it's probably in that realm, and but it's not in terms of the fact that many of them work without any kind of publishing administrators, and they don't quite know. So it's speaking to the audience of folks who might not have pub admin. Will there be some resources, or is there something you can kind of shed some light on that area for us?
Yeah, I think the answer is definitely yes. So some of exactly what data fields you should be prepared in gathering is somewhat related to the open rulemaking. So I think there's a little bit of, we've proposed what fields we think that the digital services should send into the MLC and what fields that the MLC should report out to the copyright owners, which includes, you know, self-pub songwriters. So you could take a look at that. I think, and when we finalize that, we will put out information to make it clear. And I'm sure that the MLC and the digital services will also do that as well. The MLC right now has a sort of sketch of information they suggest you should get ready, which you could look at their website. And I think also you could look at the Copyright Office rules if you have time to do this, and look at which unique identifiers you should have, making sure you know all of the titles that your song may be listed as well as there's a duty if you are in the MLC database to list all of your sound recordings and help those matching efforts and to get into their portal. Now, I understand that will be open this summer, but I think part of the you sort of put your finger on an issue, right? Like you can't actually go there quite yet. You can sign up to receive updates. But right now, it's more about getting your data in order, and we will work on promoting digital materials when it's very clear this is what it looks like, this is what you do. And I know the MLC is very committed to that also.
Great, thank you. Wesley, I'll let you go to questions right now, and then if I have another one, I'll come back. Oh, you're on mute. You're on mute. Mute.
All right. I do have a couple questions of my own, actually. A couple based off of artists with whom I actually work and some of the situations that are changing in music right now. So what has become a little bit of a common practice, particularly when marketing a release that might get pickup on something like TikTok, there are parts of songs that become searched for more and more and more frequently than the actual titles. So people have been changing the titles of works in order to make them more discoverable online. How are we as the recreators of this work supposed to make sure that we're updating basically all of the different versions of the title itself that have been distributed? And is that something that you've encountered any major problems with thus far?
I think that's a key question, and part of the data issue. It will probably look at it in our study, but all of the services receive different feeds from record labels of titles, and sometimes that information is updated, and they might present it different on their services, because some of them might group featuring so and so with it, and they want to separate it out, or how they're going to define the artist. I think that's related to that. And the idea that the title may change or might become known by a variety of different ways, because it's you might call it one thing, but everyone starts to know it by the hook or something, is a good point. And having all of your alternate titles ready and figuring out and identifying what you think your song is known by will be important, as will having a registered ISWC for it, or an ISRC, a universal identifier for your song, because regardless of the title doesn't have to be the only way that your song can be identified. So those numbers should not ever change regardless of how it starts getting referred to in a TikTok.
Cool. And then just a little bit of a side question again as well before we dive into the questions that we've received from the audience. There's been a lot of talk around dances and copyright, and when can a successful dance, actually become something that's copyrightable. And I work with the artist who has the biggest song ever on TikTok, which has an incredibly famous dance, which has been written up in the New York Times all the way over to featured on Ellen and Oprah and things like that. And I'm wondering, is there any kind of progress or ongoing conversation or interest in just kind of the copyright community around introducing different copyrightable elements to dance?
Yeah, choreography can be protected, and so choreography has a specific definition in the 1976 Act, and it kind of does go back to what we were talking about with the Stairway to Heaven case, because a simple dance step, or what is called a social dance, is not subject to copyright. So sometimes it's in the public domain, but it's also how much do you want to regulate people's movement? So that's not considered choreography, but a combination of expressive movement elements definitely can be protectable by copyright. And there was a litigation a couple of years ago that ended up getting dropped where there's a variety of them suing over emotes in the game Fortnite. I don't know if you saw that it was like the Floss or the Carltons were sort of just brief libs that raised this question, and we were following it along with a lot of the copyright communities. So it probably depends on, just as in the case of a song, it's like 3 musical notes is probably not going to be enough, or maybe the Floss, which is very popular but it's pretty short. What the dance is, whether it shows that modicum of creativity subject to copyright protection, but lots of dances are copyrightable.
Yeah, cool.
I think one other point to make on that is, if you are trying to get a choreography registration, you should make clear that if you're sending the video in, it's not an audio visual work. I think some people in their litigation, discovered that they had a registration for not the choreography, but for something else, and make sure you own it, of course, as well. So just a practice point.
Cool, that makes sense. First and foremost, there is a question at the top of, I think, most of the participants' mind is, can they get a copy of this presentation? Is that something that we will have clearance to share afterwards, or do we not have an answer on that yet?
I think we want to make sure our comms group is okay with us giving permission for our release. They probably are, but nothing we have said today is copyrighted, because we are the government, which cannot create copyrights in what we're working, and we're doing this as part of our jobs. So definitely it would not be copyright infringement.
Fantastic.
So,
okay.
Yeah, but as a resource, some of the, the points and having some of the bullet points has been really useful. The rulemaking slide, for example. So to the extent that you can
let me
share any of that, that would be great. And I know that, sorry, Wes, I'm moving over to some folks were wanting to know because I was getting texts as well, what the website, if you could just repeat what the website is, where the the MMA resources are again.
Sure, it's copyright.gov/music-modernization.
Great, thank you. Go ahead, Wes, keep going.
Great. One question, what is the kind of timing looking like on the AM/FM Act? And I'll start with that.
I don't think it's ever easy to predict timing before Congress. What the MMA was initially started in around 2004, 2005, as CIRA. So it could be that long, it could be shorter. We have a Congress ending, you never know. I think that Congress is very interested in finding as much compromise as possible. And certainly I would think that the situation with the coronavirus may delay things, but because frankly people, it's harder to talk, it's harder to meet in person and discuss different issues. But the Copyright Office has no timeline for Congress. We advise Congress when they have questions for us. So it's just very hard to tell from our perspective, I would say.
Cool. And then I think what kind of advocacy can, what kind of getting the word out around MLC and, comments around that would you, kind of want done by a manager? Like, what is, I guess this person is asking, what is the best way that we as managers can get the word out about MLC comments and other parts of that situation?
I think that part of a manager's duty is to first know about this. If they are asked a question about what is the MMA, what are the rules that are changing, so they can talk to their individual artists. But when we did the symposium in December, my panel was, how do we educate creators? And trying to press our panelists into giving an answer was, they said everything, right? They said, some creators learn by visual arts, some don't go to the internet and won't download your handouts. They really learn by their community, and communities are very different. So if you are a manager participating in a certain artist community, I think the important thing, if nothing else, is to tell them that this is something that if you are a songwriter, singer-songwriter, or just a songwriter, it really does directly affect you, and it's very important to take control of your this is your rights. These are how you get paid. Getting credit is how you win awards, and to relay that there are important places you could go, including the Copyright Office and including the MLC.com, where you could find out more information about this. But if nothing else, word of mouth is very important, and I think as a manager, being prepared by knowing what this change is, and knowing that come 2023, if you're not in the MLC's database, you are not due your statutory royalties, and they may start being distributed to people who are in their database. That's an important thing to know. I think we are hoping that all the publishers are going to get their information in there. I think the bigger concern is the self-administered songwriters. And it's important to get your information there, even if you don't have music on an interactive service. If someone covers your song, which they can do under the law, then you are due royalties. So I think just getting the word out about how important this law is and where to find more information is probably the biggest ask.
Can I add, I think we forgot to mention, but we have a weekly or a periodic email listserv you can sign up that will just give you alerts, like when there is an action item. I know you can sign up at the MLC.com too for their information, but if you go to our page, you can get on the listserv and you can be one of the conduits towards information. And in terms of the rulemakings, I mean, some of this information we have said is what should be the threshold at which the MLC needs to pay out a royalty check. Should it be $2, $5? It depends if you want to be mailed a check or direct deposit. And if you have views on that, take a look and just tell us. We really want to hear from the people that this is intended to affect. So it doesn't matter if you're not a lawyer. We consider comments all the time that don't have to be, pretty, because it's very helpful to us to hear what is going to be useful in adjusting. We've tried to do our best, but if there's something you think we're missing, we want to gather information and be able to say that, because I think, as John said, the self-published songwriter or sort of people who are not currently being caught in the old system is part of what this law is trying to do. So we want to get the word out.
Cool. I think, Nita, that's all the questions that we have from inside the webinar. If you have any additional ones, I know we get texts, questions across the session as well. If you have any, now's the time.
No, I'm good. I think we've covered a lot here, and it's definitely 12 minutes past the hour, so I don't want to keep our fabulous guest speakers any longer. But any last words, Reagan and John? Anything else you'd like to impart? Are we good?
No, but I mean, thank you for being here, and thank you for inviting us. It's definitely our privilege.
Yeah, wonderful. Thank you.
We definitely appreciate it. And for others who are interested, the Copyright Office, if you reach out to our Public Information Education Office, once we are back in the normal times, or perhaps by video conference, we will again be going out and talking to the world about the MMA. If you're interested in having us talk to you, contact them. Their contact information will be on our website and under Education and Outreach under the MMA resources page. And we'd love to continue this conversation, but thank you again for having us.
Thank you so much.
Thank you both. So thanks everyone for joining us. Until next time, Wesley, what's our next one? We're not sure, right?
Next one is on Tuesday, which will be royalty exchange, discussing catalog deals and different ways to get valuations and sell in a marketplace.
Yeah, wonderful. Thanks for reminding me. Royalty Exchange is great. Yeah, there'll be 3 great people from that company to talk about catalog valuation. So, and making the most of that. We are looking forward to that. Thank you again, Reagan and John, U.S. Copyright Office. And till next time, bye everyone.
Bye guys.
Take care.
Right.